Hello, everybody. So I'm carrying on with tort. So I'm going to look at other cases to do with psychiatric injury, and there are a few of them. But it used to be that the thought that the main reason that the courts were like this when it came to psychiatric injury was so that claimants could only win if they satisfied the conditions to be a primary victim or a secondary victim. And there are lots of different ways in which psychiatric injury can be occasioned. And this is an area which is rapidly evolving as societal attitudes shift. So how about parturition? So the postpartum situation, especially if there's been a traumatic birth, is something where there are lots of medical negligence actions. In Wild against Southend University Hospital NHS Foundation Trust 2014, a parent failed as an action because he had sustained some psychical harm when he witnessed his stillborn infant being born. Everyone knows there's a possibility, so don't watch if you don't think you can take it. It was a long process, and then they realised that the child had died in the womb, and this was held different from Walters. In Wild, it was found that negligence which occurs before the birth, that means that the mother and baby are treated as a single entity. Remember, there's en ventre sa mère, where there is that legal principle to do with property, but generally speaking, you're not found to have legal personality before birth, which is why abortion is legal in some circumstances. So if an injury to the baby is an injury to the mother, and she's seen as the primary victim, not the infant. There was a different case where a grandmother, she brought a claim for negligent management delivery of her grandchild because she saw the immediate aftermath, and she succeeded. In Ray A. Child and Others against Calderdale and Huddersfield NHS Foundation Trust 2017, the grandmother was seen as the secondary victim, and because she fulfilled the criteria under Alcock, because it was a single and shocking event. So she suffered PTSD and she recovered damages. There are also rescue cases. It used to be believed that a rescuer who sustained psychiatric injury as a result of taking part in distressing situations could recover damages. Chadwick against British Railways Board 1967 was about that. White against Chief Constable of South Yorkshire. The House of Lords found that rescuers are under the same obligations as primary and secondary categories, so they're not treated more favourably. So the claimants were police officers who'd suffered psychiatric injury as a result of saving some of the people who were injured in the football match, the Hillsborough disaster, same case as Alcock. They couldn't win as secondary victims because they had no close bond of love with any of the people. They weren't there, children, parents, whatever, wives, husbands, and they couldn't succeed as primary victims because they themselves were not imperiled physically. And the trouble is, if we did grant them this, then what are we going to do? Not send the police into dangerous situations, or the fire brigade, or ambulance crews? Because, oh no, we'll have to pay out so much compensation. If you choose to be in the emergency services, you know you're signing up to face some very harrowing scenes. And if you can't take that, don't do that job. So, how about people who are employees? In White, the claimants said that they could claim as employees because the negligence was that of South Yorkshire Police. The House of Lords found there were no different principles about the employment relationship, and the claimants, even though they had that relationship, still had to prove their primary or secondary victims, and they'd failed to establish that. There were claims of families in Alcock, and these have been dismissed, and that was very important in White. This was thought to be unjust in the situation to allow police officers to recover when some relatives had not. Now, their noble lordships, the judges, they admitted the police officers were not simply observers. And this is what was said. They were all on duty at the stadium, but they were all involved in assisting the course of duties in the aftermath of the terrible events, and they all suffered debilitating psychiatric harm. The police officers therefore they're entitled to argue, that they ought to provide compensation for the wrong which caused them harm. This argument cannot lightly be dismissed, but I am persuaded that a recognition of their claims would substantially expand the existing categories which compensation can be recovered for pure psychiatric harm. Moreover, as a majority in the Court of Appeal was uncomfortably aware, the awarding of these damages to police officers sits uneasily with the denial of claims of the bereaved relatives by the decision of the House of Lords in the Alcock case. Close quotation. So now there's plenty of authority that employees who have claims against their employers can, in particular situations, succeed when they're exposed to work-related trauma. The relationship between these claims and the psychic injuries is rather opaque and debatable. In Walker against Northumberland County Council 1995, Hatton against Sutherland 2002, it was found that special control mechanisms for psychiatric harm claims from accidents, as set out in Alcock, are inapplicable to claims of psychiatric harm which are due to occupational stress. Lord Justice Hale in Hatton described an employer's duty thus: it is to take reasonable care. What is reasonable depends, as we all know, upon the foreseeability of the harm, the magnitude and of the risk of harm occurring, the gravity of the harm could take place, the cost and practicability of preventing it, and the justifications for running that risk. Close quotations. So anyway, let's look at assuming responsibility and close relationship. There are some rare cases about this, and there are no overarching principles. The law is very uncertain in this area. Will a defendant be liable for causing psychiatric injury by carelessly misinforming someone, or by informing somebody of the truth when that's done in an insensitive manner? It could be that a principle will come out that the defendant should be liable if there's an assumption of responsibility to safeguard a claimant against psychiatric injury, or if there is a continuing relationship between the parties, which means that such a responsibility is to be borne. In W against Essex County Council 2001, AB against Thameside and Glossop Health Authority 1997, these issues were considered at length. In W, Lord Slynn said that the Primary and Secretary categories are not apposite in every case. The House of Lords said they would not strike out a claim by parents to whom a local council was in breach of an undertaking as a foster child known to be a sexual abuser. So they'd taken a foster child into their home, and the local council knew this child had sexually abused other children, and therefore this couple's children were at risk for that person. The House of Lords said, we're not necessarily accepting that argument, but there is an arguable case. It can be put. We're not dismissing it out of hand. The foster parents had their own children molested by this older child they were looking after, and the parents therefore suffered psychiatric injury. They had some of the criteria of secondary victims, except that they did not actually witness the abuse. Alternatively, unlike most secondary victim cases, there had been a continuing relationship between the council and the parents as to their suitability to act as foster parents. In AB, patients were informed by letter, which is not face-to-face, that they had been exposed to a risk of being infected with HIV by some health staffer. So there was a duty of care, and that was admitted by the defendants. There was found to be no liability, for the reason that there is no breach, because the claimants were not able to prove that their injury was caused by the means of informing them rather than the information itself. Had they been told face-to-face, they might still have suffered some psychiatric injury, because it'd be a distressing and worrying thing to be informed about the threat that they would have an incurable disease. So bear in mind there's no liability for risk of injury, only for actual injury. In Greaves against F.T. Everard and Sons Limited 2007, a claimant had negligently been exposed to asbestos during his work. It was a very rare case because exposure to asbestos can cause fatal illnesses, and this knowledge that someone can get this fatal illness could cause a claimant to be very worried and so fretful that they suffer a clinical depression. Now, this person hadn't suffered any physical injury, but it was just the worry was causing him harm. It was found that if an event occurred that could cause psychiatric as well as physical injury, then that would be recoverable. But the event had not occurred. The psychiatric injury was only caused by the worry that he might contract the asbestos-related disease, and the fear itself is not something which is actionable. In Greaves, the claim was about hearing about a bad event and not about something which had actually transpired. In Page and Smith, 1996, the claim was about a psychiatric injury which was caused by something which had already occurred. So there are all sorts of propositions for how the law should be amended. The Law Commission wrote a report called Liability for Psychiatric Illness 1998, and they suggested that for primary victims, the law should be developed only by the courts. But they said that secondary victims, or people who rescue or who are involuntary participants in these events, the Commission said that statutes to remove what it needed to be passed to remove what it regarded as unduly onerous limitations and liability for psychiatric injuries that were inflicted through negligence. The principal proposals were that the restrictions about geographical or chronological proximity should be done away with. The need for this sort of shock to be sudden should also be struck out, and it said that the necessity of demonstrating a close bond, which was amorous or familial, with the direct victim had to be kept. They said that the category relationships where these ties are presumed ought to be widened. In White, it was also admitted that these days the courts accept that there is no clear difference between body and mind, and there's no qualitative distinction to be held between psychiatric and physical harm. But it would be a very different suggestion to say that there's no difference to be made between the principles about recovering damages in tort for a physical wound and for a psychiatric injury. There are policy reasons which are important in making the law the way it is. To permit claims of policemen would majorly widen the law in this area, and the categories which compensation can be recovered for solely psychiatric harm. Further, awarding damages would seem to fly in the face of denying claims to people, to kin who were bereaved in Alcock. Lord Stein noted, the law on recovery compensation for pure psychiatric harm is a patchwork quilt of distinctions that are difficult to justify, close quotation. But the chance was not taken to go over Alcock again and possibly reformulate the law. Thank you.